I'm Matthew Peddie, the host of Our Changing State Vote 2024, and on this episode, if you're voting in November, you'll have a say on reproductive rights in Florida. On the ballot is a proposed constitutional amendment that would enshrine abortion access in Florida. The amendment would effectively roll back Florida's restriction on abortions after 6 weeks of pregnancy. It needs 60% of voters to approve it for it to pass, and there's fierce pushback from abortion opponents. Even before Amendment 4 made it onto the ballot, there were disagreements about the language. Attorney General Ashley Moody argued it would confuse voters. In a brief asking the state Supreme Court to keep the amendment off the ballot, Moody said it would, quote, lay ticking time bombs that will enable abortion proponents later to argue that the amendment has a much broader meaning than voters would have ever thought, end quote. Well, to help explain what the amendment says and what it doesn't say is Louis Varelli. He's a professor of law at Stetson University College of Law. Louis, thank you so much for joining us.
Thank you for having me.
Opponents of the amendment say it's open to interpretation, is it?
Well, everything's open to interpretation, but I don't think in the way that Attorney General Moody suggested. I think the amendment is actually a very straightforward explanation of what it's trying to achieve. And for those of us that have been following the jurisprudence of abortion for decades, it's a pretty clear statement of effectively the holding in Roe v. Wade.
Is there a way, or would there have been a way to write this amendment so that it isn't open to claims of vagueness or misinterpretation or the kinds of challenges we've seen so far?
In this climate, I would suggest not. There may always be a better way to word something like this, but I think having read a lot of these and having taught this course for a long time, reading this amendment is pretty straightforward to me. I understand exactly what they mean, and the reason I feel confident saying that is not because I'm special, but because the terms of art that people are concerned about are in fact terms of art. They are constitutional law terms that have existed since Roe was decided and have been repeated by courts since. So, for example, viability has meant 23 or 24 weeks since 1973. There can be debates over whether it should mean that, but it has meant that since 1973. In knowing that, the use of the term viability in the amendment, I think, is a useful legal term that judges will understand.
But for people who haven't been paying close attention to this, as you have for many decades, is there a chance for confusion to sneak in?
Well, perhaps, and I think that's why programs like this are so useful, right? So an important thing for voters and their listeners to remember is that judges will have lots of opportunity to interpret this amendment. That's what constitutional law is. It is the use of a relatively general document. The U.S. Constitution is only 14 pages long in certain fonts, that is interpreted by the judiciary. So judges will have an opportunity to visit words like viability. I think the point at this stage of the process is, do we have reasonable, or in this case, sufficient certainty to understand what the amendment is getting at? And I think very clearly we do. The prohibition on, or the language that says prohibit, penalize, delay, or restrict abortion is followed immediately by a qualifier that says before viability. That is what Roe said. From 1973 until 2022, when the Supreme Court overturned Roe, the law in America was you cannot prohibit an abortion before viability. People of my age have lived under that regime their entire lives. To protect maternal health was also a holding in Roe. So since 1973, a state can prohibit abortion after viability unless maternal health is at stake. Is that a tricky term? It could be, for sure. And judges have had to think about that term, and legislatures have had to think about that term. But it's not a new standard. We've been dealing with this for half a century.
Right. I mean, there's as you say, there's kind of some back and forth over the word viability. Also, as we heard, definition of who is a healthcare provider, what that means. But what level of detail can you put into amendment before that becomes confusing for voters? Like, is there a sweet spot between brevity and comprehensiveness, I suppose?
There is, but I would suggest it's slightly more art than science, right? So from what I know, and my friends in the press will have a better idea of this, of the amount of money and time spent crafting this language, knowing full well it was going to be challenged at the Florida Supreme Court. This, in my view, as someone who focuses on the law in this area, not the politics, is that this language is as transparent and as clear as someone seeking to set an abortion standard that protects abortion at all could be.
I wonder if you could talk us through the financial impact statement that accompanies the proposed amendment. Does that add a layer of clarity, or is it kind of adding a layer of opaqueness?
The financial statement in this situation was a little unusual. So financial statements in other contexts have been done sort of in in more of an economic analysis way, in the sense of this policy choice made by the amendment will cost people this because of the way it affects our lives. The financial statement in this amendment was largely based on litigation costs. Of course there's going to be litigation about this. The litigation is going to come when the legislature passes laws about abortion and they are challenged for violating the amendment. So, for example, a parental notification law will not be one of those because that's protected by the amendment, but a parental consent law will almost certainly be enacted by the legislature, or certainly could be, right? I'm not prescient in that regard, but there is one now, so I would imagine the same legislature would be interested in a parental consent law. That's going to be challenged for violating the amendment. There's no reason to believe it will be struck necessarily. That'll be up to the Florida Supreme Court, and we know, generally speaking, the Florida Supreme Court has not been overly permissive with abortion rights based on their April 1st decision of this year. So we're going to have those challenges, but that's true in every amendment. I cite the felon enfranchisement amendment, right? The felon voting amendment led to a lot of litigation. That's always true. So to the extent the litigation is driving the costs, right, there was a lot of litigation around the 15-week ban, and that didn't seem to be sort of something that the state balked at. So this is going to happen. Will it cost real money? For sure. Is it unusual? No, and it's not really attributable to the abortion access issue that the amendment's targeted at.
If the amendment passes, do you see the Florida Supreme Court having a say in how it's implemented?
Without question, right? That's what's going to happen. So you're going to have the legislature. So it's important that people understand what an amendment does. It does set a floor of a basic right. And the right here, as I read it, and I think is, from my perspective, very clearly states, prior to viability, abortion may not be prohibited. Now, that was true under Roe, and under federal law, under Roe, parental consent was required. The U.S. Supreme Court read Roe, interpreted Roe, and said a parental consent law in Pennsylvania is okay because it doesn't burden abortion enough to be unconstitutional. So we've been through this, as I say, for 50 years, and it isn't necessarily true that the amendment wipes the slate clean. None of our rights operate that way under the Constitution. So there will be efforts by the legislature to legislate abortion. Those will be challenged by people who don't like them under the amendment, and ultimately the Florida Supreme Court will be the final word as to whether those laws comply with the amendment. That's a really important thing for people to understand. Right? This amendment doesn't work magically in our lives. It is a baseline against which legislation from the Florida legislature will be judged. And that still remains to be seen.
It's not the first proposed constitutional amendment to generate a lot of media coverage. I mean, you mentioned the enfranchisement of folks who've served sentences for felonies. That's one of them. And then, of course, medical marijuana. There was a lot of litigation around that. And there's strong opinions on this one on either side as well. It's kind of from a legal standpoint, how consequential is this proposed amendment?
In terms of the current state of law in Florida, it's quite consequential. But the way I would describe the legal environment this amendment describes, from my perspective, is pre-2022 in Florida. It's actually more restrictive than that because Florida's constitution until April 1st of this year was more protective of abortion rights. It allowed more access to abortion than the federal constitution did. But this amendment effectively enshrines the Roe v. Wade regime. And I know that, or I think that, because the language used in the amendment parrots the standards that began in 1973 in Roe and carried through all of the various permutations of the Supreme Court in 1992 in a case called Casey, and in cases after that. These fundamental features of the abortion doctrine in America never changed. Pre-viability abortion was overwhelmingly protected. Post-viability abortion was not, unless maternal life and health was at stake. And that's the way I read this plain text, what this amendment will do. So if people are trying to just think of what their lives will be like legally, it will be the way your life was, the way you experienced the law of abortion from 1973 to 2022. What I've been telling people I think is most interesting and important about this vote, regardless of how you want this to come out. So I want to be clear, the fact that I think the amendment clearly states what the law will be is not meant to be an endorsement either way of how I think people should vote. I don't think the amendment is confusing based on sort of the language it uses and why it chose that language. But in terms of the choice in November, the Supreme Court of Florida created a very simple calculus. Right? When they made their decision on April 1st about the 15-week ban, they didn't have to read the Florida Constitution to not protect abortion rights at all. What they had before them was a 15-week ban. They could have just said the 15-week ban is okay, and moved on. They made a bigger decision, and that's their prerogative. They are Supreme Court justices. They reread the Florida Constitution differently than it had been read since 1989 to say there is no protection for abortion in the current Florida Constitution. What that does is it wipes the slate clean. It doesn't mean that there aren't any protections under law. There's a statute, but the Florida Constitution is not currently protecting abortion. The amendment being voted on November does protect abortion up to viability and after viability when maternal health or life is threatened. So that simple choice is very unusual from my perspective as a Floridian for almost 2 decades now. Florida constitutional amendments I found to be in the past confusing sometimes, right? It's not always clear to me over the last 20 years when I'm voting on an amendment what it means. I don't think that we have that problem this time. I think if you are in favor of abortion not being available after 6 weeks, or you're in favor of the current state of Florida abortion law, a 6-week ban with exceptions, then you should vote no on the amendment. If you are in favor of an abortion regime that looks like Roe v. Wade, then you should vote yes on the amendment. And I think that is helpful to voters, and I'm hoping will be encouraging to them to go exercise their franchise, to go vote, because you have a pretty clean choice. If the Florida Supreme Court had done something slightly different on April 1st in their decision this year, they could have made this much more difficult a choice, or at least I don't mean difficult in terms of being torn about what to do. I mean more complicated of a choice. This is a very stark choice. No constitutional protection for abortion in Florida, constitutional protection up to viability, and then afterwards for maternal life and health, see Roe v. Wade.
I'm Matthew Peddie, and this is our Changing State Vote 2024. Louis Varelli, Professor of Law at Stetson University College of Law, thank you so much.
Thank you for having me.
Our Changing State is a production of WUSF. Our executive producer is Gracyn Doctor. Scott Wachtler produces the podcast. Videos by Warren Buchholz and Chandler Balkcom, who also does our graphics. Engineering support from Blake Bass. Jackson Harpe composed our theme music. I'm Matthew Peddie. Thanks for listening.